Hi everyone, today we are going to see the Industrial Dispute Act of 1947. We all know that for the industrial growth, there must be peace and harmony, which are the prerequisites of every organization. And the difference between two parties, let the employers or the management and the workers, arise on account of variety of causes. Among these causes, most significant causes are wages and allowances, personal matters, including transfer, promotion, retrenchment, and bonus. These are the various reasons generally out of which the industrial disputes are arised, or else the dispute between the management and the workers are arises. The relative share of wages and allowances and bonus together as a cause of dispute has been around 37% to 38% of the disputes. It has been reported. And personal matters, including retrenchment, account for personal accounts to 20% to 22% of the disputes. The most disturbing aspect of these details is multiple increase in the percentage share of indiscipline and violence as a cause of disputes over the years. So it is very important to encounter these conflicts between the employer and employer. And this conflicts between the employer and employer, employee and employer has become an inherent part in the industrial society. So it is very important to deal with these industrial conflicts. The main purpose of this uh, Industrial Dispute Act of 1947 is to ensure fair terms between the employer and employees, workmen and workmen, as well as workmen and employers. The objective of this Industrial Dispute Act is to ensure industrial peace and harmony by providing forum for the settlement of industrial disputes by negotiation. So this Industrial Act was to make provisions for the investigation and the settlement of industrial disputes and for certain other purposes. And this extends to whole of India, including J&K, and it regulates Indian labor law. It came into force on April 1st, 1947, and this act consists of 7 chapters, 40 sections, and 5 schedules. If you remember, for every statutory compliances, the policy makers refer to the most of the important thing section of Constitution, that is directive principles of state policy. Most of the people may not be knowing about this. The base of most of the laws or legislations are derived from or else this because directive principles of state policy is one of the most important part, based upon which, because the main aim of this in directive principles of state policy, it guides the policymakers for making the laws and for promoting social justice, political equality, and welfare to the people, welfare of the people. So it gives a philosophical foundations of welfare system, because it is called as a voice of the people, which is the real sanction behind every law in reality. So it is very important to know about the basics of the directive principle of state policy, and the articles 36 to 51 in the part 4 of the Constitution are covered with the directive principle of state policy. Maybe this directive principle of state policy may not be justificable, but still it is very important to learn about it, because these are the basis for the makers of the policy. Based upon this directive principle of state policy, these all your legislations are coming up. That's why this DPSP, that means directive principle of state policy, is called as the kernel of the Indian Constitution. So it is very important to have a basic knowledge about how these legislations are came. That's why I have given a small introduction. And the source of this directive principles of state policy is Irish, and the policymakers of Indian Constitution were very much influenced by the Irish nationalist movement, and they borrowed this concept of DPSP directive principles of state policy from the Irish Constitution in the year of 1937. Let us come to the topic, that is Industrial Dispute Act of 1947. So this Industrial Dispute Act of 1947 has different phases. The first enactment dealing with this settlement of industrial dispute was this Employers and Workmen Disputes Act of 1860. So this is the act prior to the 1947 Act, Industrial ID Act of 1947, and this act doesn't exist longer because I'll give an example. Because this act treats the breach of contract of the employer as a part of offense. For example, if an employer is unable to uh, work because of any reason, illness or something, if he breaks the contract, it is unable to perform the work because of any reasons, he will be punished. He will be punished for that, and it is treated as a criminal offense. Because of it, this act was this is one of the example, for instance, why this was no longer existed. The act was repealed in 1932 on the recommendations of the Royal Commission on Labour. And after that, this act, whatever the Trade Disputes Act of 1929 came into existence for the settlement of industrial disputes. And the experience of working with this 1929 Act revealed various defects which needed to be overcome by the fresh legislations. Okay, because prior to the First World War, that means 1914 to 1918, the strike was very rare phenomena in Indian industries because people they used it to live like slaves rather than workmen. There were very few industrial disputes at the time prior to the First World War. After the First World War, strikes appeared in violent forms after this 1920. After this broke up the First World War, these strikes, all the people has started revolting, realizing themselves, and these strikes appeared in the violent forms after the First World War in 1920. In 1921, two committees were appointed, one in Bengal and another in Bombay, to investigate into the matters and it suggested remedial measures on this act because the experience of working with this 1929 Act revealed various defects which needed to be overcome by the fresh legislations. According to the Industrial Dispute Act was introduced into the accordingly with the recommendations of these Bombay and Bengal committees in 1921. The fresh legislation came into existence. Okay, and the Bengal committee suggested the foundation for Joint Workers Committee, and it is a suggested Joint Workers Committee, which is a very good point. But the loophole of this Joint Workers Committee, it opposed legislative measures and intervention of government, whereas Bombay Committee advocated the establishment of industrial courts, which is very good idea. That's why the recommendations of Bombay Committee has been taken into consideration. The General Mill action in 1924, the General Mill strike in 1924, which has completely changed and forced the government of Bombay. Total situation has been changed, and it forces the Bombay government to introduce a bill based upon the recommendations of Bombay Industrial Dispute Committee, modeled on the Canadian Industrial Disputes Investigation Act of 1907 and British Trade Disputes Act of 1927. Based upon these two legislations, there is a violent form of strikes that started in 1924, and milk strike is one of the example. And because of this revolt position, the government of Bombay has forced or else has to take a step to pass a bill on this, and it has passed based upon these two legislations bill. The object of the act was to provide conciliation machinery to bring about peaceful settlement of industrial dispute. And the defect of the act, that is, we are talking about the Trade Dispute Act of 1921. The object is very good. It is conciliation machinery to bring out the peaceful settlement of industrial dispute. But there is a defect in this act. Because of a defect, it doesn't live longer. The defect was the lack of inadequate provisions for the protecting the confidential information relating to trade unions or industrial undertaking. This was one of the loophole. Because of it doesn't exist no longer, and the Royal Committee on the Labour recommended amendment of the Act uh, as a remedy action on to remedy the defect. So after that, in a Rule 81A of the Defense of India rules came into existence. So a rule of defense, Rule 81 has been added. So the Rule 81 is about the central government has adopted several emergency measures during the Second World War. In 1942 January, the government added Rule 81A to the Defense of Railway rules, to Defense of India rules, by the notification to retain strikes and lockouts. The main purpose of the Rule of 81 is restrain the strikes and lockouts. This new Rule 81, the Rule 81 has empowered the government to prohibit the strikes and lockouts in connection with any trade disputes unless reasonable notice was given. The rule enabled the government to prohibit the strikes or the lockout in connection with any trade disputes unless a reasonable notice was given, unless and until the reasonable notice, before prior notice or the prior information, they shouldn't take any lockout or strikes. This was passed. That's how they can and empowered to prohibit the strikes. And it also helped to refer any dispute to the conciliation or adjudication, and to require employers to observe such terms and conditions as might be specified. So all the employers are recommended to follow the conditions as specified. And it also enforces the decisions of the adjudication, enforces the decisions of the adjudication during the dispute. Whatever the decision that is given by award, whatever the award that is given by adjudication has to be, they have to abound to that. So that is how in August 1942, the central government promulgated on the order under this rule prohibiting strikes or lockouts without 14-day previous notice. This is what a prior notice, they shouldn't go for any strike or lockout. That is 14 days of notice. Strikes and lockouts are also prohibited during the pendency of conciliation proceedings. During any conciliation or adjudication proceedings, the strikes and lockouts are not done. They will be prohibited. They are prohibited during the pendency of conciliation or adjudication proceeding. So after this, the Industrial Dispute Act came into force. The Industrial Dispute Act was passed in March 1947 and came into force on 1st April 1947, repealing the Trade Dispute Act of 1929. This Rule 81A is it is a rule which empowered. I can say that it is embedded into the Trade Dispute Act of 1929 at the time, because of the prevailing conditions at the time. And this act introduced, and Industrial Dispute Act came into force from 1st April 1947. The act introduced the principles of compulsory arbitration and prohibited strikes without notice in respect of public policy. So the two new institutions were also introduced from this. The Industrial Dispute Act is an addition to the Trade Dispute Act of 1929, and the two editions that has been added into this added by this Industrial Dispute Act is Works Committee and Industrial Tribunals. So, and let us see, the main labor law prior to the Industrial Dispute Act is 1947, because these are I'll give some of the acts prior to the Industrial Dispute Act of 1947 that are dealing with the industrial disputes are Bengal Regulation 7 of 1819. This is the act, and the first act that has been enacted for the for dealing with this industrial dispute, and then Workers Breach of Contract Act of 1859, and the Employment and Workers Dispute Act of 1860, which we have gone through, and Trade Dispute Act of 1920, and Trade Disputes Act of 1926, and Trade Disputes Act of 1929. And next, Bombay Trade Disputes Act. In the Bombay Trade Disputes Act, they have given Conciliation Act 1934 and Trade Dispute Act Amendment Act of 1938. These are the major acts. These are the acts I can say prior to the Industrial Dispute Act of 1947. The major shortcomings of these acts were the settlement or the awards under these acts were not binding or conclusive because of above all these acts having some shortcomings, and because of the shortcomings we have molded and amended all these, we have combined all the remedies and defects we have removed to remove the remedies, defects in these, in all the above mentioned acts. This Industrial Dispute Act came into force. So, the objective of this Industrial Dispute Act. I'll just repeat one of the important things about the Act. The first point which you have to remember about this Industrial Dispute Act is this Act is to make provision for investigation and the settlement of industrial disputes and for certain other purposes. It applies to whole of India, including Jammu and Kashmir, on the first day of April 1947. That consists of 7 chapters consisting 40 sections and 5 schedules and appendix. The other related rules are Industrial Tribunal Procedure Rules 1949, Industrial Tribunal Central Procedure Rules 1954, and Industrial Disputes Act Rules of 1957. So let us talk about this objectives of this Act. The objectives of this Act to encourage good relations between the labor in industries and provide a medium for the settlement of industrial dispute through adjudicator authorities, and to provide committee for dispute settlement between the industry and the labor with the right representation by the registered trade union or by the association of employers. Okay, prevent unauthorized strikes and lockouts, reach out to labor that has been laid off, unrightfully dismissed, etc. We'll see into the what is layoff. We'll see all the definitions which is given in the objectives. That is, first one is strike, lockout, layoff, unrightfully dismissed, etc., dismissed or terminated, and provide labor the right to collective bargaining and promote conciliation. These are the main objectives of Industrial Dispute Act. The first objective is to encourage good relations, and the second objective is to provide a committee for the dispute settlement between the employer and employee, and to prevent unauthorized or illegal strikes and lockouts, and reach out the labor that has been laid off. That means through laid off means laid off compensation will be given. They'll be the people who has been laid off, they'll be compensated. So we'll go through that also in the next sessions. Provide labor the right to collective bargaining and promote conciliation. Now we'll see some of the basic definitions which are important definitions of the Act. First, we'll see into the what is industrial dispute. Section number 2K. The industrial dispute is any dispute of difference between the parties like employer, workman, and workman. These are the 3 parties. Okay, employer, employee, and employer and workman, which is connected with employment and non-employment, or the terms of employment, or with the conditions of labor of any person. Then in such conditions, if there is any difference, then only it is called as industrial dispute. If a dispute is arised out of employment or non-employment, or conditions of terms of employment or conditions of labor, then only such type of dispute is called as between these parties, mentioned parties like employer and employer, employer and workman and workman. In such conditions, then it is called as industrial dispute according to the section number 2K. Now we'll see next definition, section number 2Q, what is strike? We have seen in the objective, what is strike? Strike is nothing but it is a cessation of work. Cessation is nothing but stoppage of work by a body of persons, that means group of persons employed in any industry, acting in combination or concerted refusal under common understanding of any number of persons who are or have been so employed to continue the work or to accept the employment. That is nothing but the overall idea of it is nothing but strike is nothing but it is cessation of work, stoppage of work by the group of persons employed in the industry. And according to the section number section 200, it is 2 is not here, 200 retrenchment. Okay, retrenchment is nothing but termination by the employer of the service of a workman. It can be because of some reasons like punishment inflicted by any of the disciplinary action. And retrenchment doesn't include voluntary retirement or retirement, okay, or termination of a person as a result of non-renewal of the contract. These are the three conditions. These conditions doesn't comes under retrenchment. Retrenchment is nothing but termination of a person as a punishment for the disciplinary action. So the definition is retrenchment with the termination by the employer of a service of a workman for any reason whatsoever otherwise than as punishment inflicted by way of disciplinary action. So this retrenchment is nothing but termination, and it does not include voluntary retirement of the workman. Retirement means after complete reaching to the age of superannuation, that means retirement age, and or else because of non-renewal of contract if the contract was not renewed, non-renewal of the contract of employment, then also it doesn't come under retrenchment. The next definition is section number 2 triple K. What is layoff? Layoff is nothing but it is the inability, it is the layoff, it is the inability of the employer, it is the inability of employer to provide employment to its workman whose name is born on the master rolls of his or her industrial establishment. Okay, that who has not been retrenched, that is also important. So here what is layoff is nothing but it is a failure, refusal or inability of the employer. The causes might be because of shortage of coal or shortage breakdown of the machinery or lack of raw materials, no supply because of lack of raw materials, or there is no supply of raw materials or machinery, natural calamity, whatever the reasons it might be. It is said to be the layoff is nothing but it is an inability or the failure or refusal of or the employer to on account of given reasons to give employment to the workman whose name is born on the master rolls of his industrial establishment and has not been retrenched. Retrenched means we have already gone through. Retrenched is nothing but terminated. So if it is nothing but it is a failure or the inability of the employer to provide job to its workmen who are in the master roles because of shortage of coal, lack of power, lack of electricity, raw materials, or natural calamity, breakdown of machinery, any reasons he is unable to provide job to his employees who has been appointed, who he has recruited. And the next is we'll see. We have in the starting we have seen the causes of the main causes or most significant causes of industrial dispute is wages and allowances, personal matters, transfer, promotion, retrenchment, and bonus. We have to. So in this Industrial Dispute Act, we will be going through the definition of average pay. Section number 2 AAA talks about average pay, which means the wages payable to the workmen in case of monthly paid workmen, 3 complete calendar months, the payment which is paid for 3 complete calendar months, or weekly paid, or 4 complete weeks paid, or daily paid in the 11 full working days preceding the date on which the average pay becomes payable if the workman has worked for the 3 complete calendar months or 4 complete weeks or 12 full days. So that is what average pay is. Now we'll go through the important definition. What is meant by award? Section number 2B of the ID Act talks about what is award. Award is nothing but it is an interim or the final determination of any industrial dispute or any question relating to by any labor court, industrial tribunal, or adjudication. I can say adjudication, like any labor court, industrial tribunal, or national tribunal, and includes arbitration award made under section number 10A. Also, award is nothing but it is final determination or interim which is given by labor court or industrial tribunal or national tribunal. And now we'll go to the next definition, lockout. Lockout is nothing but, in simple way, it is as strike is a weapon in the hands of employee, this lockout is a weapon in the hands of employer. That means lockout means the temporary closing of a workplace or suspension of work or refusal by the employer to continue to employ any number of persons employed by him. It is nothing but it is a type of strike, while it is a type of refusal to closing the organization or its industry temporary, make it to just like while the employees are making the strike for satisfying their demands, to make the management to accept their demands. In the similar way here, lockout is quite opposite to that. A strike is a weapon in the hands of employees. In the similar way, this lockout is a weapon in the hands of employers. Okay, which forces employees to it is a weapon to force employees to see his points or the demands to be accepted by them, to make them to accept their demands. This employer will be closing the workplace temporary or suspension of the work and refusal of employee to continue to employ the employees, workmen. Okay, so now let us talk about the procedure for strike. It is mentioned in the section number 22 1, subsection number 1. In this, no person is employed in a public utility shall go on strike in breach of contract. At times of breach of contract, there is no strike should be taken place. Okay, and without prior notice, no person, without giving any prior employer notice of the strike, as here in after provided, within 6 months before striking or within 14 days of giving such notice before the expiry of the strike, no strike can be taken place, or during the pendency of the conciliation or the adjudication proceedings, there shouldn't be no strike. These are the conditions of procedures they have to follow. Without prior notice, nobody can go for strike. Prior notice within 6 months before striking and within 14 days of giving that notice. Okay, they have to give 6 weeks prior notice to the employer, and after giving the prior notice, within these 14 days of giving such notice, they shouldn't go for strike. And it is also remember that before the expiry of the date of strike, they'll be mentioning the strike, they will be going to do that strike, and before the expiry of the day of that strike date, they shouldn't go for strike. And during the pendency of any conciliation proceedings or adjudication proceeding, no strike can be taking place. Now we'll go for procedure for lockout. According to the section number 22(2), no employer carrying in any public utility services shall lock out in any of his workmen during these conditions. The same conditions which you have applied for strike, the same conditions: 6 weeks prior notice. That means 6 weeks prior before locking out, and after giving the prior notice, they have to, within 14 weeks of giving such notice, they have to wait. Okay, after that, before that expiry of the date of lockout, they specified in any of the notice has foreset or during the pendency of conciliation or adjudication proceedings, and 7 days after conclusion of such proceedings. These are the same, it is similar to that of a strike, and the section number is 22. Now we'll go for something which is very important, as we have already gone through the definition of layoff. Layoff is nothing but it is the inability of the employer to provide job to his workmen who are in the mustered roles. So let us see what is this compensation. Layoff compensation is the right of worker, because according to this section number 25C of the Industrial Dispute Act, a workman who is laid off is entitled to the compensation. That compensation is called as laid off compensation, equivalent to the 50% of the total basic wages and plus dearness allowances for the period of layoff. So what is that here? The section number 25C talks about layoff is nothing but it is not the problem from the side of, if the problem is not from the side of workmen, then if the problem is with the employer who is not having the ability to provide job or else employment because of any reasons, lack of machinery, lack of raw materials, or breakdown of machinery, or natural calamity, whatever the reasons might be, if he is not in a position to provide employment to his employees, in such cases he has to give the compensation. It is a right of the workman. Okay, they can be entitled to compensation equivalent to the 50% of the basic pay, total basic wages, and dearness allowances for the period of layoff. This right of compensation is, however, subject to the following conditions. The conditions is like whatever said, he is not a badli or casual worker. His name should be in the mustered roll, and should have not less than 1 year of continuous service. Well, please remember, for getting a layoff compensation, the first is his name should be in the mustered rolls. He should be a on-roll employee, and he should have a continuous service of 1 year continuous service under the employer. Under the employer, he should have continuous service. Here we'll see what is continuous service. Continuous service in regard to layoff compensation is, according to section number 25A, a person is said to be in continuous service if the period is uninterrupted service, if he is for that period in uninterrupted service. Uninterruption means it can, some of the considerations in the uninterruption means, if he's working but still because of health issues, illness, sickness, authorized leave, accident, a strike which is not legal, a strike which is not legal. So in such conditions, this where the fault of the workman is not there, then in such condition this can be considered calculating the period of continuous, then if that period is also considered as a period of continuous service. So main thing which for getting the compensation, they have compensation, they should be continuous service, means uninterrupted service with under the employer, and he should there can be an interruption in the service at times of sickness, unauthorized leave, authorized, it should be only authorized leave, sickness, or accident, strike in which there is no fault of the workman. Then it will be considered as a continuous service. Now we'll see most important topic is authorities for the investigation and settlement of industrial disputes. The main purpose of the Industrial Dispute Act is settlement of industrial disputes. So industrial dispute, in this act they have given authorities for the investigation and settlement of industrial dispute are: one is works committee, that is section number 3 of Industry ID Act talks about works committee. Section number 4, conciliation officer. 5, boards of conciliation. 6. Court of Inquiry. 7. 7. Labor Court. 7A. Labor Industrial Tribunal. Sorry, it is not Labor Tribunal, it is Industrial Tribunal. And 7B. National Tribunal. Let us talk about each and every one. Now, Works Committee section number 3. The Works Committee is a committee consisting of the representatives of both employer and workmen. Okay, the main objective of this is they'll be dealing with the day-to-day problems in the industry so as to regulate the smooth running of the organization or else industry. The function of the industrial committee, works committee, is to ascertain the grievance of the work employees and to arrive at some agreement. The committee is formed by the general or special order by the appropriate government in an industrial establishment in which having 100 or more workmen employee. The first condition which you have to remember is it deals with the day-to-day issues arising in the employment, and the second one is this committee is formed by the general or special order by the appropriate government. Appropriate government can be the state government or central government in the industry which is having 100 or more workmen are employed in any day in the proceedings of 12 in the preceding 12 months. Okay, so works committee is it which is having both the representatives of employee employer, and it deals with in solving the problem arising in the day-to-day working. And third point is it will be established in any of the industrial establishment having 100 or more workmen are employed. Okay, next we'll deal with the conciliation officer section number 4. The appropriate government with a special notification in the official gazette appoints such member as it deems to fit to be conciliation officer. It can be one or more than one, and he'll be charged with the duty of mediating. Remember, this bit is very important. Duty of conciliation officer is there is no adjudication, he'll be mediating. It is the duty of conciliation officer is mediating. He'll be charged with the duty of mediating and promoting the settlement of industrial disputes. The conciliation officer may be appointed by the specific area or for the specified industry in a specified area or for specified industry or either permanently or temporarily. This conciliation officer will be appointed by the government by notification of official gazette, and he'll be charged with the duty of mediating, and he can be appointed for specified area or specified area of industries or either permanently or for a limited period of time. Now let us see the Board of Conciliation, section number 5. This appropriate government, the same here, Board of Conciliation also, the appropriate government will be through a notification in the official gazette constitutes a Board of Conciliation for promoting the settlement of industrial disputes. The board shall consist of this Board of Conciliation consists of chairperson and two or more other persons, two or four other persons as appropriate government deems to fit. So the chairperson, one shall be in the four two or more persons, one chairperson and two or more other persons, one shall be the women. So in this, let us see, the chairperson shall be independent person and other persons shall be appointed equal number from the represented parties to the dispute, and any person appointed to represent a party shall be appointed on the recommendation of that party. In case if the party fails to represent or recommend any person, then the government will be appointing such person whoever it feels is suited for that position. And the board having prescribed quorum. Quorum is nothing but quorum. The definition of quorum is nothing but the minimum number of members that are required to conduct a meeting. Okay, the minimum number of members that are required to conduct a meeting is called as quorum. So it is board means more than one member, then it is called as a board. So a board having a prescribed quorum, okay, may act withstanding the absence of the chairperson or any of its members or any vacancy in its member, provided that if the appropriate government notifies the board that service of the chairman or of any other members has ceased to be available. The board shall not act until the new chairman or the members, as the case has been appointed. Until and unless new chairman appoints, it cannot go further. Now we'll go for the court of inquiry. Courts of inquiry, section number 6. The same here also, the appropriate government by a notification in the official gazette constitute this court of inquiry. Okay, and it consists of one independent person or such. Yes, two or more. One independent person and two or more other persons. One of them shall be appointed as a chairperson. A chairperson will be a independent person, and this court of inquiry is having a quorum. The minimum quorum is nothing but minimum number of members that are required to conduct a meeting. Okay, it is similar to the board of inquiry. And next is labor court, section number 7. The labor court, here only one person will be appointed, which is who is called as presiding officer. The appropriate government by notification in the official gazette constitute one or more labor courts for adjudication of industrial disputes relating to matters mentioned in the second schedule. We'll be having, how many schedules we'll be having in this act? Generally, we have 5 schedules in this act. So the schedule number 2 is the matters that are specified in the second schedule number 2. That matters will be dealt by the labor court. Okay, and schedule number 2, and for performing such functions as may be assigned to them under this act. So the labor court consists of only one person, will be appointed by the appropriate government, and he is called as a presiding officer. The qualification of the presiding officer, who can be appointed as a presiding officer? The person who has been a judge of high court or having an experience not less than 3 years as a district judge or additional district judge, or he might be having an experience of acting as a judicial officer not less than 7 years, and he can be acted as a presiding officer of any labor court constituted under any provincial act or a state act for not less than 5 years. So remember, qualifications are, first is he must act as judge of a high court and should possess an experience, or he can have an experience of 3 years experience of as a district judge or additional district judge, or 7 years, not less than 7 years experience as judicial officer, or 5 years as presiding officer of any labor court. Then he can be, such person will be qualified to act as a presiding officer. So tribunal, section number 7A. Tribunal, it is under adjudication. This works, this is also tribunal. Here, industrial tribunal. Tribunal 7, section 7A is the industrial tribunal. The tribunal, this is the appropriate government may, by notification in the official gazette, constitute one or more industrial tribunals for the education of industrial dispute relating to the matters mentioned in the schedule number 2 and 3. Okay, so it deals with the matters both 2nd and 3rd schedule mentioned in the 2nd and 3rd schedule, and for performing such functions as they may assign to them under this act. So section next is, this tribunal consists of only one person. He is appointed, he or she will be appointed by the appropriate government. He is a presiding officer. The qualifications are same. He has been a high court judge, or 3 years as a district judge or additional district judge, or same, what are the 7 years experience, not less than 7 years experience, or as a presiding officer in any of the labor court. These are the same qualifications he should possess to act as a presiding officer for industrial tribunal. Okay, now national tribunal, section number 7B. The same this here, not the appropriate government, national tribunal, because these deals with the issues having national importance. Okay, and the issues, this national tribunal dealing with the issues that are involving the questions of national importance. So in the central government maybe by notification in the official gazette constitute one or more national industrial tribunals for the adjudication of industrial tribunals. In the opinion of central government involving the issues or the matters involving national importance, so will be dealt by them. Okay, or we can say that uh, the issues involving more than one state likely to be interested in are affected by such disputes. This consists of only one person, is the presiding officer appointed by the central government, and who is not qualified or appointed for the presiding officer for the national tribunal is if he is unless he has been a judge of high court. The qualification of to be a presiding officer for the national tribunal is if he has not been worked as a high court judge, he cannot become a presiding officer of the national tribunal. Okay, and now disqualification of the presiding officer for national labor courts, tribunals, or national tribunals, industrial tribunals, and national tribunals. No person shall be appointed to or continue in the office of presiding officer in any of the labor court tribunals if if he is not an independent person or if he attains 65 years of age. These are the two conditions under which he cannot act as a presiding officer. Right, now we'll go for the penalties. Penalties section number 2Q. Penalties like layoff penalty, layoff and retrenchment. Layoff, it is nothing but if an employer, it layoff and retention both will be done by the employer. If they are doing any layoff or retrenchment without permission, without notification or without any notified permission, then according to section number 2Q, any employee who controversies the provisions of section number 25M and section number 25N shall be punishable with imprisonment of a term which can be extended to 1 month and with a fine which can be extended to 1,000 rupees or both. So the penalty for unintimated or controversies of provisions mentioned in the section number 25M and 25N for the employer is the penalty is 1,000 rupees and imprisonment is 1 month of imprisonment, and some cases it can be both. And next penalty is unfair labor practices. And unfair labor practices means any person who commits any unfair labor practices shall be punishable with imprisonment, 6 months of imprisonment and 1,000 rupees of fine, and it can be both. So for layoff, retrenchment, and for unfair labor practices, it is 6 months of imprisonment, extended to 6 months of imprisonment, and the fine money is also extended to fine of 1,000 rupees or both. Okay, and now we'll go for the next penalty: illegal strikes and lockout. Section number 26. Any workman who continues or otherwise acts in furtherance of a strike which is illegal under this act shall be punishable with imprisonment which is extended to 1 month and a fine which can be extended to 50 rupees or with both. For illegal strike, it is a 1 month of imprisonment and a fine of 50 rupees. And any employee who convinces or continues furtherance of a lockout which is illegal strike or lockout kada. So now under this section he shall be punished with imprisonment of term 1 month and a fine of 1,000 rupees or both. For illegal strike, the employee workman will be punished with 1 month of imprisonment and 50 rupees, whereas for employer it is 1000 rupees. Thank you very much. Thank you for listening. And this is very important act, and you can go for the some of the case studies which are very important. Dimakuchi Tea Estate versus Dimakuchi Tea Estate 1958 is very important. Look after the Supreme Court laid down some of the objectives of the act. So for prevention of illegal strikes and lockout, and relief to workmen in the matter of layoff and retrenchment, and promotion of collective bargaining. So please go through that, and you can also see the cases of Steel Authority of India versus Union of India. Please go through these case studies so you'll get more and more knowledge on this act. And the other case study you can also prefer to see is Hindustan Lever Limited. Okay, thank you very much.